forget about it. We're more concentrated to analysis, but I think it would be misleading for us only to analyze. I suggest only to make a synthesis. So, let us to see what is the place of the International Criminal Court in the context of other international criminal tribunals. I will read several tribunals here. It's not all of them, but let us see their practice and how this practice coordinates with practice of International Criminal Court. I will look at the practice of International Criminal Court for Rwanda, International Criminal Tribunal for the former Yugoslavia, Special Court for Sierra Leone, Special Court for Lebanon, and of course ICC itself. First of all, let me raise a question about legal way of the creation of international criminal courts. Let's start from the Yugoslavia and Rwanda tribunals. All of them were created by the decision of the Security Council. But again, if we look into the United Nations Charter, we will find very interesting thing. There is no articles that could be a legal justification for the Security Council to create these tribunals. Of course, in the resolutions of the Security Council there is a reference to the Chapter 7, but this reference in no means justifies the creation of this tribunal itself. This reference explains only one thing, that the Security Council would like that this resolution be treated as legally binding to all states. There is also a very interesting thing. If we look into the travaux préparatoires, stenographic notes of these meetings of the Security Council when these resolutions were adopted, we will find very interesting speeches of the representatives of states who said, for example, the representative of China said indirectly, yes, we understand, we just adopted decision without legal justification, but politically, because of political reasons, we voted in favor. So, even the members of the Security Council understood that the creation of these tribunals was illegal. The same could be said in a certain extent to another tribunals. For example, the Special Tribunal for Sierra Leone. The Constitution of Sierra Leone does not provide for any other courts, including this special one. If you look at the legal way of the creation of International Criminal Court for Lebanon, it is again very, very interesting example of the violation of international law. Here it is the citation from the speech of the Russian representative in the Security Council after the adoption of the resolution creating this tribunal. You could see what the Russian representative said. He said the arrangements chosen by the sponsors is dubious from the point of view of international law. The treaty between the two entities, Lebanon and the United Nations, by definition cannot enter into force on the basis of a decision of only one party. To make it clear what happened, this tribunal was created by the treaty signed between Lebanon and United Nations. But Lebanon refused to ratify this treaty. Okay, said Security Council, we're entering into force this treaty by our resolution. Again, we see very, very dangerous precedent of violation of the very essential basic norms of international law. That international law is constructing and building by the voluntary participation of the states. So, analyzing the very first question of legal creation of these tribunals, we see that all of them were created. Well, I'm not say quite straight, they were created illegally. Let us to see the what was the legal activity of these international criminal courts and tribunals. I think the example of Special Court of Sierra Leone is quite interesting one. You see that the main trial of this court is Charles Thabo trial. Sometimes it's very interesting to see who are the judges. Here are the three main judges, but they were not the only one who constitutes the bench. There is also a very interesting judge, Mr. Meziaev from Senegal. And let me present you two pictures about the bench before the pronunciation of judgment and after it. So it clearly shows that something happened with the judge. And this judge is not fallen sick or refused to attend the hearings. The judge was removed by his fellow judges. Why? I still could not excuse myself from a crime I committed myself. It was a crime when I sit in front of a computer when this judgment was pronounced in live and I did not press the button to record it. Because after I could not find it in internet. You couldn't find anything in YouTube. Anything. Any wishes. But this, what happened on this pronunciation of judgment, you could not find anywhere. What happened? After the three judges said, Mr. Taylor, you are guilty. They stand up and trying to leave the courtroom. But in this moment, it was clear that somebody started to talk. My first impression was that it was Mr. Charles Taylor who is talking, probably expressing his viewpoint of these judges. But later on, we all realized that the fourth judge is still sitting and that he who is talking. He is trying to say something, but suddenly the microphone was cut and the blinds started to put on the glass that prevents the public to see what's going on in the courtroom. So that's how the court officials treat the fourth judge. But after that happened, the judge was removed, but later on he was able to express his position on what happened in the trial. Meziaev said, international justice cannot be based on rumors. They are mass crimes. We must have the highest standard of proof. But this highest standard of proof never been provided in this trial. Let me add to you from my own practice of participation in international criminal tribunals. There is a very big contradiction between our expectation from international criminal tribunals and the reality. I never seen the lowest standard of proof in my life what I see in international tribunals. There are some other expressions of Mr. Meziaev, you could see it on the screen, but the main idea of what Mr. So tried to say, the deep judgment that three judges just read out in the court, were never discussed between them. Where this judgment came from, I don't know, said Mr. Meziaev. But this judgment was not discussed between us. Special Court for Lebanon. It is another interesting example how international courts are destroying international law. As I think I'm coming, even the moderator is showing me that I have only a few minutes. I think I need to announce finally that my idea is, we are coming to the idea that international courts are destroying international law. Example of this special court for Lebanon. Just one example, trial in absentia. International law says that CCPI is covenant for civil political rights, that the determination of any criminal charge against him, everyone shall be entitled to the four minimum guarantees to be tried in his presence. Special court in Special Court for Lebanon said special tribunal shall conduct trial proceedings in the absence of the accused. ICC, the case prosecutor versus Mr. Chui. I hope that you enjoy this. This is quite a general in my presentation because it's completely new idea. The judge acquitting Mr. Chui said the following: accused, the fact that we are acquitting you does not mean that you are accused. I think that it should be known for us, lawyers. We should take this idea because International Criminal Court said that it's produced the highest level of justice. It was also a very interesting case when the same judge convicted Mr. Kazan several days ago, and I really was very much awaited the pronunciation of the judgment. This day I pressed the button record, but unfortunately nothing happened because I expected the judge said, accused, we are convicting you, but this does not mean that you are guilty. But unfortunately it does not happen. We still have only this expression. The same judge. So, I understand that my time is, yes, almost finished. And let me just bring my final conclusion. What is this ICC is about? We clearly see that all these courts, and ICC among them, are very sharply, very consistently violating international law. There are two main directions in this violation. First, the court is breaking already existed norms of international law. And second group of violations, it's a producing law itself without any justification for that. Of course, you understand that court could not produce law. Court is only applied law, but not international criminal courts. The international criminal courts are clearly starting to produce. And this brings me to idea about the definition of this activity of international criminal tribunals. And I put it in the context of the history of international law. We all know that before 1945, the international law was very different. This international law treats war as a legal instrument for states. It accepts colonialism as a legal tool. It accepts the division between civilized and other states and so on and so forth. And only after the creation of the United Nations Organization and United Nations Charter, international law became different. This law started to make by all members of the international community and the interest of all members of the international community. That's why we start to call this modern international law as progressive international law. This word progressive really reflects the essence of this new law. But whether after 1990s the international law retained its main features, in my opinion, it is very clearly, we can very clearly see that it is not. The international law became deformed, and this deformation would be called regressive and even repressive. In this slide, I enumerated the main features of the regressive international law. To conclude, if we listen about the activity of International Criminal Court and tribunals, and ICC especially, from mass media, we could not understand the reality of this institution. But if we put this court in the context of the modern development in international law and international relations, we start to understand that these court and tribunals were created with that purpose of the destruction of international law. So this destruction of international law is not collateral damage when these courts are trying to achieve the officially proclaimed goals. No. The real idea, the real goal of these courts was to create new repressive international law. After we understand this, all these strange events in the practice of international criminal tribunals becomes clear. Trying to obey the procedure, I conclude my presentation, and I thank you very much for your attention.
Thank you very much for a very exciting lecture. Professor Alexander Meziaev, I think you have traversed quite a wide terrain of looking at not just the International Criminal Court, but also looking for recent developments, the special tribunals, like the one for Rwanda, Yugoslavia, but also special tribunals in Sierra Leone and so on. And from that point of view, this was a very useful lecture and public lecture, really looking at where is international criminal justice. Where is it coming from? Where is it now? And where is it going? And your conclusion was that it is going through destruction of international law as we know it. Regressive rather than progressive. But more of what you have really traversed, focusing on the International Criminal Court, under the Rome Statute, which is at the Hague. I think you have given us some insights by the analysis of what is happening. We hear that a lot. So some of the questions we would like maybe to interrogate or think about or research is, how did the International Criminal Court, the ICC, come about? It was not a Security Council created court. And if it was created through negotiations and where countries participated, which countries participated in it, until the final adoption of the statute did they do so voluntarily, or did they do so through ignorance of what they were doing? We need to ask those tough questions, because sometimes it is one thing to participate in creating a devil, but when the devil starts doing the real work, then you complain. So where were the leaders of Africa and the leaders of the rest of the world who are now waking up to the reality? Did they really participate in the crafting of the Rome Statute? The other which I think is important is, of course, the role of the Security Council, which you have mentioned, which is problematic. Because the Security Council, the permanent members, some have not ratified the statute itself, but they seek to judge, to send cases to the International Criminal Court. That is something which ought to be looked at. But also coming to Africa, and I hope this will come out in the discussion in the next 30 minutes. We have a situation, for example, on the Libyan case, where UN Security Council 1973 of 2011 did authorize some action to be taken in Libya. The NATO alliance took that and intervened in Libya and organized the assassination of the president and so on. Now the question there also, we should reflect, we in Africa, or some of our members in the Security Council who are not permanent members, like our own country here, South Africa, voted for that resolution. Of course, our president, a year later, went back to the summit of the Security Council to say, we passed the resolution, but it was abused in the process. So all this we need to look at and really try to deal with. And lastly, as we debate, let us also try to factor in what the African leaders did last October when at the AU summit they passed a resolution there urging President Uhuru Kenyatta and al-Bashir not to go to the court, and some threatened that they are going to withdraw from the Senate. But they are not withdrawn. They just, when they get together, some of the leaders make a lot of noise when they're in a group. But when it comes to withdrawing, you do it country by country. And they are scared of doing it. Or they didn't mean that they will do it. So I think that there's a lot that we need to discuss, particularly with the young people. But not everyone in this room are lawyers. So express yourself the way you understand the nature of the International Criminal Court and Africa from whatever discipline you come from, or just as an African citizen, thinking as a citizen. You have a right to do so. You don't have to be a lawyer to discuss justice. So let us now open for questions and comments. Make them very brief so that we can hear a number of voices. I will try to balance men, women, but also a bias towards the young, the youth. but the elders should not feel that I will discriminate against them entirely, because I belong to that group. Okay, let us now, please tell us who you are. Is there someone taking the mic around?
Yes.
Please do. I will just point, you are going to be one. Lift your hands so that you get 1, 2, 3, 4, 5, and then we see whether there is another round, depending on how quickly we go through. Some will be comments, some will be questions. And be very brief and precise. I think I will use this mic so that it goes around also. That's number 1. Where was number 2? Yeah. So questions will be asked, all those 5, and then response. Then we see the second round. You are number 2. Number 1.
Oh, thanks. Hi. Thanks, Prof, for your presentation. My name is Thabo. I'm a journalist. I actually have been following most of these cases at the ICC quite vigilantly. Professor Alexander, you actually, your comment just started listening to my first question, which was that, last year the African governments got really bold and they held this big summit and they were all really angry about Africans being dragged to the ICC. But I fail to sympathize with that as well, because I think specifically of all these ICC cases, the Kenyan case is the only one where they volunteered to have the case referred to the ICC. It was actually the Kenyan Human Rights Commission, if I understand, and the Minister of Justice who actually took the case there, and it wasn't actually the ICC that itself imposed itself onto the Kenyan government. You can correct me if I'm wrong. But I think, we all know and understand the power apparatuses and the influence that the Security Council has on not only the United Nations, but I think also within the functions of African governments. But my question for us as Africans is, at what point in time are we going to be responsible for our own intra-African legal judicial system? You've got the African Commission on Human and People Rights in the Gambia, but yet to my knowledge there is no case of human rights that have been committed, that has been tried there. So I think the ICC is less for me a question of, the West is badgering these poor Africans, and more a question of when are we as Africans going to have our own judicial system and have that courage to take ourselves to court, more importantly.
Thank you. My name is Mbeki, African activist and politician. Okay, I'll be short. The first one I would like to understand is this a recent case of Kenya, and how Kenyan president was brought forward into this unjust law of this ICC. And my question based on this one would be, what is it that the AU can do to have some teeth to bite, or could they also be independent from this system of this ICC as a continent, to take a position to say we do also do not recognize, like China and Russia is called. My second one will be Gaddafi assassination of brother leader from Libya. I still fail to understand the intervention and entrance of NATO, the NATO regime into Africa, into Tripoli, to make sure that they killed brother leader Gaddafi, and still nothing was done to them. And they were never questioned and taken into this ICC court. Why not? Is it because they are not Africans? My last one will be the position that the AU should take for an African independence.